Hello, viewers. Welcome to Africa and Beyond Television Network. And this afternoon, we need to take a look on Zimbabwe as a case study. How the opposition leader can outmaneuver the ZANU-PF regime, which has established a complete state capture. And there is no internal remedy except the intervention of the international community. Remember that Zimbabwe went for the elections on the 23rd of August 2023, and according to the opposition, they claim to have won those elections before Zimbabwe Electoral Commission, with the help of the state apparatus, outmaneuvered them and presented fake results. What is happening at this moment in time is that the opposition in Zimbabwe, led by Advocate Nelson Chamisa, has refused to accept the outcome of the elections. And they didn't go to either the Constitutional Court or the Electoral Court in the nation of Zimbabwe, since they were citing that these courts are captured. This was later confirmed by the cases which were brought by Citizens Coalition for Change, as well as the imposter called Sengizo Chavangu, who is actually on the rampant of recalling members of the Citizens Coalition for Change, who are MPs and councillors. Let us get straight to the point today. How can the opposition in Zimbabwe outmaneuver ZANU-PF regime and force things to be settled by the international community, particularly the United Nations, where Zimbabwe is a full member and a signatory? Let us explore. There is what is called the International Court of Justice. What is the International Court of Justice? How does it work? It's very important for us to take note and understand how the International Court of Justice works. What happens is that Citizens Coalition for Change leader and the president, together with his party, cannot take the Zimbabwean government or the state to the ICJ. ICJ is a forum where a state can take another state for justice to prevail or for a determination to be reached. In this case, what it means is President Nelson Chamisa and his party cannot take the regime in Zimbabwe to the ICJ. But what happens is that a neutral country, even a country with no interest in Zimbabwe politics, can take Zimbabwe to the ICJ for a determination. Reasons being, if you go to the SADC, there is an SEOM report which clearly states that the Zimbabwe Electoral Commission failed to deliver a free, fair, credible elections as per the Zimbabwean Constitution, number one, and as per the international laws, particularly the SADC guidelines on the governing or the running of democratic elections. What it means is there is international jurisdiction which might be obtained against the government in Zimbabwe. What it means is any nation can take the Zimbabwean government to ICJ to make a determination on this matter and find closure. So what is going to happen is that if Nelson Chamisa and this party makes this move to approach any particular nation, they will face the patriotic bill, which was put into effect by ZANU-PF quickly before the elections because they wanted to protect themselves from this move. They knew about this and they created an environment where they wanted to protect themselves from any citizen lobbying for any state, any other state to move against them. What can be done? The only remedy available is for a Zimbabwean who is not in Zimbabwe to move a petition online so that it is signed by the citizens of Zimbabwe in their numbers. Once they manage to lobby for the signing of the petition and the person is outside Zimbabwe, what it means is the country approached can then take this matter to ICJ and make a presentation. Once a presentation is made, Zimbabwean government is obliged to be part of the proceedings. If they decide not to attend, the matter will be heard in their absence. And since the ICJ is an arm of the United Nations, its resolutions or the court outcome will be binding on the nation of Zimbabwe. And if Zimbabwe fails or refuses to acknowledge the judgment, it means the United Nations will be forced or compelled to place sanctions on Zimbabwe. So this is the process. So at this moment in time, the only international avenue after SADC is for any person who is not in Zimbabwe to lobby any neutral country to move this case to the ICJ against the government in Zimbabwe. And you present the report from the EU, the report from the African Union, the report from the SADC, and the concerns from the main opposition in Zimbabwe, particularly the judicial capture, which is evidenced by the recalls which were made by Shavangu, who is an imposter, which means the Judicial Commission of Zimbabwe and its judges failed to protect the interests of the citizens of the Republic of Zimbabwe, particularly the people who voted for Citizens Coalition for Change MPs and councillors who have been recalled by an unknown person within the structures of the organization. People have been recalled without the instruction of the party itself. So, in this case, I'm convinced that actually be followed. Let us take a look on some cases. The ICJ, which is situated in Peace Palace in The Hague, in the city of Netherlands, was established in 1945 as a way of settling disputes between countries. The court also have been referred to it by other authorized UN organs, which means there is a second option. We have organizations like SADC, they are recognized by UN, like AU, they are recognized by UN. They can also push for an advisory opinion on legal questions pertaining the issue of Zimbabwe. After they have given advice and opinion, then the matter can be taken to ICJ. So this is very important to note. One of the key interesting issues, let us try to find the importance of the ICJ. It is the 93 UN member states. This means that it makes an important contribution to global peace and security, providing a way for countries to resolve issues without resorting to conflict. Which means South Africa, which always complain about Zimbabweans migrating to South Africa, and we end up having these people being burnt alive. South Africa would have eased that burden by simply taking Zimbabwe to ICJ to compel Zimbabwe to hold free, fair, credible elections, probably supervised by the United Nations, because the United Nations Charter facilitates for that. What kind of cases can be brought to the court? The court can rule on two types of case: contentious cases. These are legal advisory opinions on legal questions referred to it by United Nations organs and certain specialized agencies. This is the reason why I mentioned SADC, AU, and other specialized agencies. We have United Nations acknowledging that indeed the elections in Zimbabwe were not freely and fairly done. That is the starting point. So if you take a look on the case brought by South Africa against Israel on 29 December, this is a contentious case where a decision has to be made by the court, which means if the ICJ rules in favor of South Africa or in favor of Israel, that decision will be binding. And if Israel fails to take heed of any decision, or if South Africa fails to take heed of the decision, then sanctions can be applied. So let us take a look another case study, which is very, very important. Okay, before we go to the case study, any UN member state can bring a case against another member state, whether or not they are directly in conflict, when the common interest of the international community is at stake. What has happened is that Zimbabweans have become a menace across the globe, and any member state of the United Nations can bring the case against the government of the Republic of Zimbabwe, whether they are directly in conflict or not. It doesn't matter. Any country can take this matter to the United Nations Court called ICJ. For example, we have the case between Gambia and Myanmar. Gambia was not directly concerned by the genocide allegations which were leveled against Myanmar, but that did not preclude the country from bringing the action on behalf of the Organization of Islamic Cooperation. So we have what is called the CCC in Zimbabwe. It can move their action through another country. Like what happened, the Organization of Islamic Cooperation approached the Gambia, and the Gambia, on behalf of this organization, then approached the International Court of Justice. So this is the procedure which we just made a decision to bring right here. Let us take a look on the consequences of a court ruling. The rulings of the ICJ are final, and there is no possibility of appeal. It is up to the states concerned to apply the court's decisions in their national jurisdiction, and in most cases, they honor their obligations under international law and comply, which means under international law, they are compelled to comply. If they fail to perform the obligations incumbent upon it under judgment, the only remaining recourse is to turn to the Security Council, which can